Last forever, just as divorced spouses in Massachusetts and maybe soon in Connecticut, New Jersey, and Oregon. It's the end of alimony as we know it. And do you feel fine? Good evening, I'm Christopher Naughton. Welcome to the American Law Journal. Alimony reform hasn't taken over the nation, not yet, but in Massachusetts it has. And some people say there have been victims. Here's a report from ABC News in Boston.
I think it's a sin to put people my age out there.
Jackie Kinsman is 70 years old and divorced since 1996. She was receiving lifetime alimony payments from her ex. Then
I was served with a paper informing me that because of this law, he was taking me back to reduce or eliminate alimony.
effective this past March, Jackie lost all alimony and her medical insurance. The alimony reform law, which took effect last year, was designed to encourage self-sufficiency.
And they will have the ability to know that their alimony will end at some time, whether they have to go back into the workforce, whether they have to be smart with the alimony payments that they are getting during that allotted time.
Alimony payments are now based on length of marriage, and they end at retirement. Jackie's husband retired at 67, then went to court to modify his alimony agreement. She says the new law leaves senior citizens out on a limb.
This is meant for somebody my daughter's age group, 45. You know, you've out there, you've worked, you've had college experience. It's not to put grandmothers and grandfathers on state aid.
These women who anticipated that they were going to receive alimony for their ex-spouse's entire life are now being told that that might not happen.
Judges do have discretion to continue payments for needs-based or other reasons.
And if a court or a judge feels that they have shown good cause for that alimony to continue past the retirement age, that is a possibility.
But that didn't happen in Jackie's case. She says she's lucky she owns a home, but wonders why senior citizens are denied the security they were promised so long ago.
Whether the law is unfair or not, I think it should have been grandfathered. Are people in their 80s and 90s being hit by this?
Three great guests with me tonight. Let's go ahead and meet them. Bonnie Frost returns to the scene of the crime here on ALJ. It's been about a year since we've seen Bonnie, a partner with Einhorn Harris, Asher, Barbarito, and Frost, one of, if not the largest family law practice in the state of New Jersey. And Bonnie is the chair of the matrimonial mediation and arbitration section for her law firm, and also now 27 published cases to her credit. Steve Hittner joins us for the first time tonight. He is the one responsible for getting the law passed in Massachusetts. Wouldn't have happened without him. He is very much into divorce mediation, and he'll tell a bit of his story this evening. And Don Spry is with us once again with King Spry, Herman, Freund, and Fall. Don in practice over 3 decades now, taking cases much like Bonnie to his respective state Supreme Court and all of the appellate courts in that state. Don now joining us for 23 years on the American Law Journal. Steve, let's go to you first. Compelling story for you. Now, again, you helped get this law passed in Massachusetts. It's having a spillover effect in the country, but it probably wouldn't have happened if you didn't go through this yourself. You own a print shop, and the judge hit you up for alimony, lifetime alimony, $865 a week or something to that effect.
Yes, $865 a week for life. When my business started to go into a downturn around in 2000, I tried to get a modification, and no matter what I could do, I couldn't be credible that I couldn't afford to pay the $865 a week.
Now, certainly the judge must have looked at your income, which obviously had to have been in the hundreds of thousands if you were, you know, paying.
Never was.
It never was. So if you care to share with us, I mean, alimony, was it kind of a 50-50 split as far as the numbers go?
No, alimony was based on what the ex-wife demanded.
And what the judge exceeds to, obviously.
What the judge exceeded to.
But $865 sounds like a big number for someone who, you know, is not some sort of industrial magnate.
It was a lot of money. I couldn't get a modification. I went into a lot of debt, eventually had to go bankrupt. And I decided that something had to be changed. And it was not the lawyers or the judges, it was bad law. And I set out to fix it.
So you went to the court and you say, look, I'm on the verge of bankruptcy. Can't you amend this alimony? I'm paying $865 a month. I'm not a week. I'm not even bringing anything like that in a week. What does the judge say to you? Pound sand?
Well, I said to the judge, I can't even pay next week's alimony. She said, well, then you're not cooperating, and I'll put you in jail.
Did she ask you to like drain your credit cards, use your credit cards?
It didn't matter. As long as I had any asset to go through, I had to run my mortgage up as high as I could, run my credit cards up as high as I could, and then once you're totally destitute, then you end your alimony or you get a modification, maybe.
Does any of this sound strange to you as far as maybe what would happen in New Jersey or Pennsylvania? Are courts loath to amend alimony payments? I know when it comes to support, we've talked about custody and support, change in circumstances, the kids need better shoes, they need a little bit more food, better food on the table. You're making more money, Mr. X, so yeah, you're going to pay more in custody. But when it comes to alimony, aren't courts loath to change that?
I don't know if the term would be loath, but I think it's more difficult to change alimony. I think that once the equitable, in Pennsylvania, alimony and equitable distribution go hand in hand.
Sure.
So it's sort of a package. And I think judges will require much more evidence for a modification. In other words, it can't be a 10% drop in income necessarily.
Right.
It has to be something more than that.
Would you have, Steve, what would you say? Your business dropped off, what, 50%? Let's just use a round figure.
Well, it dropped off about 70%, really,
okay,
from what it was. You know, in Massachusetts, the receiving spouse needs to be maintained to the lifestyle of the marriage.
Right.
So no matter what you could say, you could not get a modification to lower the alimony. It's interesting also.
Yeah, but if you don't have the money, how is she going to be able to maintain the lifestyle? If she was living with you, she wouldn't be able to maintain that lifestyle.
Not a credible argument.
Your argument, no doubt.
Not a credible argument. The law says she has to maintain the lifestyle. You know, it's interesting, when I began the website, Mass Alimony Reform, I thought I was the only one with the problem. And people started coming out of the woodworks, especially women who wouldn't get married because they were afraid their income would be given to the second wife.
So, and Steve, let's go ahead and let's continue with that story. So, you know, the judge says basically you may have to go to jail. Sorry, you know, Mr. Hittner, but you're going to have to, you know, exit the courtroom and you're going to have to keep paying no matter what your change in circumstances are. You're going to have to keep paying your ex-spouse alimony. So the next step you take is, and it's kind of an inspiring story, whether people agree with you or not, what one man or one woman can do. You start a grassroots movement that, you know, quite literally now has got some national spillover effect.
Yes, I began a grassroots movement with 3 other couples whose they were basically the second wives who were interested in this because their income was being either imputed to go to the first spouse or they wouldn't get married to it. And we began publishing the horror stories of different people who came to us. And as we published the horror stories, more people came out saying, gee, it happened to you too. I thought I was alone. And before we know it, we had this groundswell of people getting the horror stories published by the media.
Now, he mentions the Second Wives Club, which I think is an interesting aspect of this. These are women, and I never knew this about alimony. I'm always learning something new on these programs. These are women who are saying, look, the way the laws are set up in many states is if, you know, the guy I'm going to marry is paying alimony to his spouse, and I come into this new marriage, and I've got lots of assets, you know, that's going to help his ex-spouse. And so there are a bunch of second wives out there saying, I'm not getting married to this guy so that I can pay alimony to the ex. That has to come up in your practice.
Well, the way they do it is they say it's all available household income.
I understand that, but we don't do that with custody and support. Why do we do that with alimony, Don Sprague?
Well, it's not supposed to happen in Pennsylvania. In Pennsylvania, the new spouse has no obligation to the old spouse. Okay. But I think Steve's right. The way lawyers will try to argue it is say, we're not including your new spouse's income, but what you have less expenses because your spouse is contributing to the expenses. Therefore, it's more. It is the same thing, and I don't see that as much in my cases that the new spouse's income is included. I can't say it doesn't happen or it's not considered, but I haven't found it to be a problem across the board.
And Bonnie, in custody and support, that issue doesn't even come up. You can never say, well, my ex married some really wealthy guys, so now I don't have to pay you as much support, but really it would be the same principle, wouldn't it? What would be the difference?
Well, in New Jersey, a new spouse does not contribute to child support.
Okay.
So, and that's completely part of our law.
Right.
And
most states are like that.
And as it pertains to alimony, there is no published case, but certainly it would be. I think it would be smack of unfairness that you would expect some other spouse to support a new spouse. I mean, there's nothing per se in our law that says you shouldn't do that.
I'm sure that that lawyers are going to bring it up even by way of innuendo, like she's well taken care of.
I have a question.
Well, maybe
financial.
so. Maybe so. But I wanted to respond to something that Steve had said earlier. One of the cases that we've had in New Jersey where self-employed payors of alimony are looked at more differently than the W-2 employer because the judges may think that that person can manipulate the income So that is an issue, that because it's the lack of the truthfulness, I guess, that they perceive that one could have. But the idea that Steve said that in Massachusetts, which is different than what we have in New Jersey, that the wife has to be maintained, the ex-wife has to be maintained into the standard of living. Our alimony law talks about where the payor spouse is going to be at the time of the divorce and what his standard of living is as well. So both standards, both parties, when they leave the marriage, we look at both their standards of living, which is, it sounds to me as if it's different than what was happening in Massachusetts.
From what I understand from the people I've spoken to in New Jersey, the biggest objection that they have is the lifetime alimony problem.
Well, we don't have that in New Jersey. And unfortunately, in our statute, it talks of, as it stands now, it does use the word permanent. But after 1980, there was a case called Lepus, and it said that there can always be a change, modification, even a termination of alimony, but if there are substantially changed circumstances. So there is no such thing as, quote, lifetime alimony. It's really a misnomer. And unfortunately, there is that word permanent in the statute.
And so why is there a movement afoot? And Steve, I know, has come down to speak in New Jersey. They've asked you to speak at various forums, Steve. Why then is there a movement afoot? And why is New Jersey maybe one of the first 4 or 5 states after Massachusetts seriously considering it? I mean, it's in the State House, right? Has it passed any of the chambers?
It's been referred out to the Senate Judiciary Committee. I looked at the website today, and that was the last I could find.
Is it in limbo?
No, I think it's being studied. I don't know what that quite means.
But there's a movement afoot. We can't just say this is purely political. Somebody is saying...
No, there's definitely a movement afoot in New Jersey. And I think a lot of it came about after the recession in 2008 and 2009, when payors were hit with needing reductions in support because of what's happened to them in the economy and happened to so many people. And judges were not granting them a modification of alimony because their change of circumstance hadn't been lengthy enough. And there's been a hue and cry in the legal community saying that that wasn't fair as well.
Here's the problem. People can spend 30 years in jail knowing that someday they're going to get out. People have to have a sunset to their alimony at one point in time in their life. They have to be able to prepare for their retirement. Someone cannot prepare for retirement if they're paying 30%, 35% of their income towards alimony. The receiving spouse gets a chance to retire for life, but the payer can't ever possibly do that unless they're very wealthy and moneyed. And it's also unfortunate when you have permanent alimony, because the receiving spouse who gets that thinks that they never have to prepare to be self-sufficient. And with the turmoil in today's economy, and I'm sure it's going to continue, everybody has to have some way of being self-sufficient. And if they don't plan on it, God help them when something happens that they have no ability to do that.
I think one of the issues that we see in Pennsylvania that's troublesome with alimony, Steve, is that Bonnie talked about alimony being modified based upon a substantial change in circumstances, and that's the way it is in Pennsylvania. And one of those substantial changes in circumstances is the retirement of the payor, the person that is paying the alimony. And I see a distinction sometimes between W-2 wage earners and small business people, in that a W-2 wage earner retires, starts getting a pension when they're 65, 66, 67, that age. And even though there's testimony, sometimes I try to put testimony on in cases that when the parties were married, they both agreed that when they were at a certain age, they were going to retire and go to Florida, and then argue to a judge that the alimony should stop because the recipient shouldn't be in a better position being divorced than they would have been had they lived together. I find the judges are all over the lot on that. Some will permit a reduction or a termination of alimony based upon a substantial change, and others will say you have to keep working. So it can be an issue.
Here's an even bigger issue that I found and got agreement from everyone on. Unless there are guidelines and structure with the ability for a judge to deviate in certain and extreme circumstances, then there's no consistency and predictability. You well know as an attorney, as both of you as attorneys, you want to be able to tell your client pretty much what's going to happen. But from one county to another without guidelines and structure, it's impossible.
I think that's legitimate. That's legitimate. It's your result could depend on the county, could depend on the judge for the same facts.
You know, it always seems that the court has been trying to get to something equitable. And what I'm concerned about with some of these laws is, will judges have their hands tied? It's kind of like with criminal law. Once they put in mandatory sentencing, some judges, you know, had very little leeway to do what they thought was fair. They were in the courtroom, they heard the testimony. When it came to parsing out a sentence, the legislature said, here's what you're going to do. Ultimately, the court wants to get to an equitable situation. So whether it's equitable distribution or alimony or a combination thereof, is there a possibility that with laws like this being passed in states, that judges' hands could possibly be tied?
It's a danger. I mean, I think it has to be a guideline, but there has to be ways to deviate for legitimate purposes. I mean, I think if it's a flat-out, straight guideline, that can be just as unfair, I think.
Let's talk about what's actually happened. Our law was put into effect on March 1st, 2012. And what's interesting about it is that people who were going in for modification, and by the way, it was a scheduled modification, everybody just couldn't run to the courthouse. What's happening is people are negotiating settlements. About 90% of the modifications are being settled that way, without a judge having to rule. They're negotiating very good settlements, too, and they're actually, in many cases, becoming friends again, because they can be parents to their kids again without the animosity of paying alimony. Now, the reality of it is that in our law that we passed, a judge has judicial discretion to deviate from the guidelines if there's clear and convincing evidence of need. And yes, the burden has gone to the person who has the need to prove need, as opposed to the other person having the ability to pay.
Yeah, that is a substantial development in the law. And when you're talking about the burden of proof shifting, that's a major sea change.
Our courts look at both the ability to pay and the need.
Well, so do we.
It's not just one or the other. And you know, I don't know if you're ever going to get a perfect world with alimony. I mean, you know, you're talking about making payments to somebody you've divorced, and if you're going to remarry, then and that new spouse sees the money going out, it's going to be an issue. We're
talking alimony reform today. It's happened in Massachusetts. It may happen in Florida, Connecticut, Oregon, and New Jersey might be next. What will happen after that? When we return, we'll also take a look at fault. Can marital fault actually impact your alimony? Back in just a moment.
And the first thing they do when you go to jail is they revoke your Social Security right away.
If I died, then of course it's insurance. But if I got sick,
until the death of either party.
It's double the amount of money I make.
So what we called it was a death sentence.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
Time Magazine published this issue. Very knowledgeable, very passionate about the topic. Bonnie Frost with Einhorn Harris, Asher, Barbarito, and Frost. Steve Hittner joins us tonight. He hails from Massachusetts, and that's where he staked his ground, fought the good fight, and one man made the change there in Massachusetts. And now, Steve, you're giving talks really all over the country about alimony reform, are you not?
I'm still fighting for it. I think it's something that needs to be done.
Right. And Don Spry joining us again this evening from King Spry, Herman, Freund, and Fall. Being into a courtroom, you represent a client. Maybe they're in their 60s. You know you're going to argue for alimony. What does it look like, and what does that initial disposition look like?
Well, in New Jersey, if I have an older couple, and I say older meaning 60, because there are less earning years in front of the 60-year-old than there are in front of the 40-year-old. One of the discussions that, if I don't have it, depending on who I'm representing, the other side surely is going to have, is when is this going to end? Because clearly everyone has a contemplation that they're not going to work forever. I mean, there are some of us who might be working forever, but in general, people have a contemplation that they're not going to work forever. So that becomes a very large piece of the negotiations. And so in one case, we negotiated a settlement where it might have been a lower number of alimony, but a guaranteed term, so that there would be no changes. My client was guaranteed that there was going to get the money. No, for like 6 years, maybe, something like that.
Okay.
7 years, so that the husband at age 67 or 68 was stopping work as well. So they were both stopping.
Okay.
or something like that. But, you know, that is always going to be a subject of discussion when you have older people getting divorced.
It's a big problem because many older people are getting divorced today, where they weren't getting divorced earlier. You know, when people were dying in their 60s and 70s, they stuck it out. But now people know they're going to live to their 90s. They're saying, well, maybe I don't want to be with this person for the rest of my life. And they want to make a change. And when that happens, wow. How do you deal with that? We dealt with it in Massachusetts by saying, well, listen, someone in that situation may have to get alimony for over the retirement age. So they may have to get a better distribution of assets for a while. They may have to get, they're going to get half the retirement, they're going to get Social Security, but at least there is going to be some kind of a sunset to it.
Well, and I think that's right, both what Steve and Bonnie said. The problem is the older, you know, if you're older and you have a child that's a minor, most of the judges are going to say you owe an obligation to the child. You've got to continue working until the child becomes a majority in Pennsylvania, which is 18.
Sure.
But when you're dealing with a spouse and someone wants to retire and the wife, if that's the situation, is going to be getting Social Security based upon the earnings record of the husband, then there is either a termination that could be contemplated or a reduction. And I find it very difficult in my cases to deal with retirement dates and obligations of people that are 60 and older.
You know, what's interesting though, Bonnie, and again, we've raised this before, again, we understand, and I think women understand now that there's been such a change. Many women are working, there's greater parity than there used to be. Women are more highly educated, more women are graduating from law school, for example. But still, we can't ignore the fact that still today, a woman on the average makes about 78 cents on the dollar compared to a guy. So doesn't that, or shouldn't that, and does that come into your argument if you are arguing for alimony or a bigger piece of the pie in an equitable distribution matter?
Well, it certainly comes into the argument, and maybe not per se as you've raised it, but it certainly comes in the argument because most women don't make what men make. Certainly there are women who do earn more than their husbands, and that is life. But you see, that's what... If you have a judge who is looking at the individual facts of the couple in front of them, of him or her, that's what's important. And those individual facts, in my opinion, should drive the decision rather than just the cookie cutter.
I think in addition to the other argument, even if the spouses earn equal pay, if one spouse is going to raise the children by diversification of labor and agreement during the marriage, that person's not going to end up having that equal pay when they go back into their job. They're not going to have the same contributions to their 401k. All of those things set them behind economically. That's the argument that you hear many times in support of someone seeking alimony, even if they have a good job. Although in Pennsylvania, I think the counter argument could be made that, okay, if you're earning decent money, then give more of a percentage of the assets if there are assets to give. And
I know that this is an interesting aspect because it doesn't come up that much, although it seems to have come up more in New Jersey in the last 5 to 10 years. And Bonnie, you're going to tell me why.
Oh dear.
Well, it's not. In Pennsylvania, we talk about 17 different reasons that you can get a divorce when you're looking at full-based divorce, and the last one is like adultery, that sort of thing. Am I to understand in New Jersey and many other states as well that that marital conduct, in other words, some faulty conduct on the part of one of the parties could impact alimony monetarily? Let me just spit it out. Someone's an adulterer. Does that affect the number?
No.
Should it affect the number? Does it, as a practical matter, affect the number? I think it does.
No, it doesn't.
I think it affects whether you get it, potentially.
No, not in New Jersey.
No?
Not in New Jersey.
Okay, that's noble.
Not in New Jersey, because we look at it, marriage, as an economic partnership. We're dividing up the abilities to earn and the assets.
Okay.
However, having said that, if there is outrageous or egregious fault, then that can go to the issue of whether or not the spouse should be supported.
What's interesting, Steve, is that this movement has also impacted people who have decided to get married. Now, before the law got passed in Massachusetts, people got married and then they realized, my gosh, the woman would say, my new husband and the work I'm putting into this marriage is really going to his ex. So people were saying, geez, I should have just cohabitated.
But yes, we passed the cohabitation part of the law that allows for someone to file for a modification if their receiving spouse is cohabitating for a 3-month period or more. after March 1st, 2012. And the people who we were going after, really on this, are the people who were blatantly living in a common household situation, which, by the way, we gave definitions to, and avoiding getting married to lose their alimony. I mean, we've had cases there where people have actually gotten married by a priest, but not gotten married officially by the state to collect their alimony. We've had people wearing wedding rings. There's a story of one woman who was a doctor living with an entertainer and collecting alimony and refusing to get married. She was engaged but wouldn't get married. I mean, there was such blatant, I call it fraud, being committed, that we wrote in our law that if someone cohabitates, a judge may reduce, suspend, or terminate the alimony. And the idea was to encourage people to have relationships so that they would get married. And what's interesting is since the law has been passed, a lot of people are getting married who wouldn't have gotten married before.
I've got to ask, moving forward, Steve, what do you see happening here? Obviously, you got a groundswell moving in Massachusetts. Florida kind of stumbled with it. They got it through the houses, and then the governor vetoed it.
What I see very clearly is people are realizing that there has to be some type of sunset to alimony. People need to be encouraged to be self-supportive and move on with their lives. And they can't move on with their lives if they're tied together with a string called alimony. They're tied together financially. Many divorces happen because of financial reasons. Now you tie these people together financially for the rest of their lives. Wow, it's terrible. And especially with people living into their 90s today. It scared the heck out of me when I thought that my ex-wife was going to live into her 90s and I'd be paying for that long. Fortunately, my alimony obligation has been over for several years now.
Well, it's good to know that you're also planning to get to your 90s. So that's positive.
Yes, I am planning that.
Okay. Bonnie, your thoughts?
Something will probably pass and get on the governor's desk. Whether it's going to be in the form it's in now is a whole other story, because one of the proposals in the act is that anyone who has an alimony obligation now can then, after this act would be passed, could go back in and get the new alimony term superimposed, regardless of what they had negotiated 10 or 12 years ago.
Don, your last thoughts?
There's nothing in the hopper in Pennsylvania right now on alimony. But, I mean, Pennsylvania does have sort of a tradition of a wait and see. I mean, New Jersey's no-fault law came in 1971. Pennsylvania's in 1980. They were one of the last states. I think something probably will come before the legislature at some point. I think it's a sort of a wait. I don't know this, but it seems like it's more of a wait and see. I'm not aware of a ground. I mean, I understand what Steve is saying, and I think you have people in the state that feel the same way, but it hasn't reached the legislature at this point.
Cool. Great conversation tonight, folks. I want to thank Bonnie Frost. As always, great having you back here on the set. Bonnie Frost with Einhorn Harris. She spent her last 5 weeks on trial dealing with the topic that we're going to be tackling next time, which has some assisted reproductive technology issues attached to it. Bonnie Frost with Einhorn Harris in New Jersey. Steve Hittner joins us tonight, again, right at the top. He's the engine that's driving this train. Alimony reform, successful in Massachusetts, and probably we'll see it happening in other states. Steve, thanks so much for being here tonight. And again, whether people agree with you or not, again, I think it just demonstrates, we always say, what can one person do? Where does it start? You took action. You kept going. There were probably a couple of dark days there, but you shook hands with Deval Patrick there in Massachusetts, and you saw your bill pass. So good on you, and congratulations.
By the way, it passed unanimous in the House and the Senate.
Nice. Democrats and Republicans.
Across the board. Men and women, Democrats and Republicans.
Very good. And of course, Don Spry with King Spry, Herman, Freund, and Fall, lending his 30-plus years of experience to our topic tonight. So for all of us here at the American Law Journal, thank you for joining us this week. Until next week, case closed.